The basic structure is, and we only have bench trials. Yeah, for claims for damages or injunctive relief, it doesn't matter, there are no juries, only bench trials. There are 3 judges on the bench, 1 presiding judge, 1 reporting judge who's writing the opinion, and 1 further judge. And as I've said, they are all specialized. So you could say the Mannheim court, for example, has about 300 new cases a year, and there are 2 panels, so each panel has about 150 cases a year. So the judges are very experienced in patent matters. There is only 1 hearing, and that hearing is usually between 6 to 15 months after the filing of the complaint. And up to that 1 hearing, the briefs are exchanged. The court would set deadlines. So usually it's 3 briefs for either side, and could be more. Sometimes you file shortly before the hearing, you file further briefs. And then the judges deliberate on the case on the day before the hearing. So in the Mannheim court, the hearing is on Friday, and on Thursday the judges would convene and deliberate on the case. And then during the hearing, they would also openly present you their view and would ask the lead counsel of each side to comment on certain issues, but not to do a comprehensive pleading. Yeah, they really expect to have a sort of an expert conversation. They ask or point to 2 or 3 specific issues that have not become clear yet, or where they are not decided yet, and then it's your lawyer's task on the spot to react and to convince the judge what is the right way. Only to mention that the 1 hearing issue, that's true for the major courts, Mannheim and Düsseldorf. In the interim, also the Munich court has become sort of popular, and they're doing it with 2 hearings now. So they have changed that a little bit, but that's the basic structure remains still the same. Very limited hearing, just a couple of hours. The briefs are very important, and in this connection, very important is also when you coordinate the filing with other jurisdiction. The German case needs to be fully substantiated when it is filed. There is no notice pleading or anything of the sort. Claim construction and the infringement analysis all needs to be ready. You cannot just go ahead and name the patent number, cite the defendant, and maybe cite the accused device and file the case. That case would most likely be lost. Even though there is, by the way, there is no summary judgment or anything of the sort. Yeah, so it all goes on until that 1 hearing that I've just pointed out. Yeah, but you would lose a lot of credibility, and it would look really odd if the complaint wouldn't include a fully substantiated infringement analysis. And I've seen it many times that clients, coming from the US, they think, okay, we want to now file internationally. We file in the US, and they call me, can you file tomorrow or in 2 days? And then that's very difficult, yeah, because you need to make certain statements, yeah, that could have a significant impact further down the road, yeah, and you might not have all the information yet that is necessary to decide which way to go and which position to take on claim construction and infringement. So that's very dangerous. So I would give your counsel in Germany at least, 2 months notice, yeah, to prepare that. And of course, if you're experienced, when there are certain issues, where the case could go south, and you might just be a little bit more vague, yeah, at the outset of the proceeding and see how the counterpart reacts and then get back. But you cannot just say nothing, or you at least have to be aware of which development the case could take. So that requires adequate preparation. Expert witnesses do not play the key role that they play in the Anglo-American system. And we also distinguish court experts, which are court-appointed experts, from private experts, which are experts retained by a party. And first of all, both of them are rare. Yeah? Of course, you can retain an expert here, a private expert, as I call it, and you can also submit an expert opinion, but that's by no means necessary. Sometimes it is helpful if there is a certain, for example, if there is at the priority date there was a certain understanding of a skilled reader regarding certain terminology that it is difficult to make it plausible by reference to textbooks or whatever, then an expert opinion might help. But an expert opinion is no substitute for a consistent claim construction analysis by your counsel. What the German courts really hate, if a party comes to the hearing, has an expert with the party and then tries to sort of defer, statements on the technology to that expert. The judges don't like that at all. The judges want to hear it from your lead counsel what the right understanding of the technology is. And only if there is a very concrete dispute on a very concrete technical aspect, then the court might be inclined to hear experts or to retain a court-appointed expert to help them clarify that. By the way, that's court-appointed experts, that's maybe 5% of the cases. So the German courts also decide, very complex technology, the entire field of mobile telecommunication. All of the cases I have had have been decided without an independent expert. And of course, the parties have used private expert opinions, but usually it's not the relevant point. Yeah, the relevant point is mostly it's really about claim construction and about developing a theory and an explanation that is convincing under the governing precedents. And that's really where the case is usually won or lost. Discovery, that's another basic difference. There is no general discovery in Germany. Changes have been made now. If a plaintiff has no evidence for the infringement, and it's impossible to get access to the accused device, and there is a certain likelihood of infringement, then the court can make certain pretrial orders, ordering that an independent expert can inspect a device or a certain method that might be accused. But also these elements are usually not are rare, I would think. Yeah, not I would think, they are rare. Yeah. Mostly, if there is really only a problem in terms of evidence, if a plaintiff knows, this feature, must be realized because he can't do it otherwise, or I'm of the opinion that it is very unlikely that it is done otherwise, then you would just submit the complaint, would say this feature is realized, it's actually realized in a certain way, and then you would wait for the other side to get back. If they deny, then the court would in many cases assume that the burden of proof shifts, because the court would say, it's your product. If you have a plausible theory submitted by the plaintiff, you cannot just deny infringement. You would have to explain why your accused device, because it's your product, works differently. And of course, a defendant has to tell the truth. They could just openly lie. And so in most cases, that system works pretty well with sort of shifting or balancing the burden of proof, also expecting the defendant, even though primarily the burden of proof is on the plaintiff. Here also in getting the defendant involved and to a certain extent requiring the defendant to disclose certain aspects of the accused device rather than just denying that, that the accused device works as submitted or alleged by the plaintiff. So that, in most of the cases, has worked very, very well. For damages, it's different. For damages, it's we have a first phase of the proceeding where a general liability is ordered, and the defendant is ordered to disclose all financial information relating to the sales of the accused devices. So that's a general claim that is always available, but is only granted or confirmed if the infringement as such is confirmed. So it's not a pretrial discovery in this sense. Appeal and enforcement. A first instance judgment can be appealed, of course, but what is important, it is enforceable pending an appeal. So if you win on the trial level, then the judgment, the injunction that issues can be enforced. The only prerequisite is that the plaintiff posts a security bond which covers or is meant to cover potential damages that could be incurred in connection by the defendant in connection with the enforcement in case the judgment is set aside on appeal. The patent system, and that is something you are surely more familiar with, is to conclude the presentation. I've covered now the infringement part, which is done in the civil courts, and we separate the validity part from the infringement part. So validity is litigated in different courts. Namely either in the European Patent Office, opposition proceedings, or in the Federal Patent Court, nullity actions. Just jumping, nullity actions are entertained by the Federal Patent Court, which is in Munich, and the appeals go directly to the Federal Supreme Court. So it's a very special proceeding, which tended to be lengthy, and in recent days the Supreme Court has really endeavored to speed up things, but the proceedings still take, I would say, 2 to 3 years. And it's very, very important to realize that the nullity action should be filed early on. Don't wait until you get sued. It's preferable if you know that that a patentee is going to sue you anyway at one point. File the nullity action or the opposition proceeding early on, because that gives you a head start. Because the nullity action usually takes a lot longer, and if the nullity action hasn't been scheduled to be tried when the infringement court is ruling on the infringement side, then the case is very unlikely to be stayed. So the infringement court would grant an injunction even though the validity is not conclusively decided yet. And only in exceptional cases would the infringement court stay the case, namely if there is newly discovered prior art that is getting a lot closer to the prior art considered by the patent office, and that makes it very likely that the patent is going to be revoked. Thank you very much.